Good evening, everyone. Thank you so much for joining us for our 42 BR Barristers Pupillage Evening. We really hope that by the end of this evening, you have an understanding of more about chambers, about the kind of work that we do, and about the pupillage process. This evening you're going to be hearing from a number of members of chambers, and I will introduce them individually in a moment, and they are going to be sharing their experiences of chambers with you from different points of view. At the end of that, I'm going to then do a short presentation on the pupillage process, the application process, what to expect and how that all works. And following that, there will be an opportunity for you to ask us some questions. So if you do think of any questions before that, you're welcome to send them at any point. There should be a Q&A button at the bottom of your screen. So please do make use of that function and send us any questions, whether that's to do with chambers as a whole or the pupillage application process specifically, and we will do our best to answer those at the end. So this evening you're going to be hearing from, as I said, a number of members of chambers who are going to be discussing different points of view, and they are we're going to be hearing from junior members of chambers and more senior members, just to get a flavour of what life at the bar is really like. So without further ado, I'm going to ask our first speaker, Angela Piears, who is going to talk to you about what a week would look like as what we would call a senior junior, so somebody who's more experienced. And in particular, Angela specialises in more than one area of law, so she's going to talk to you about how she balances that as a more senior member of chambers. Angela, over to you.
Thank you very much, Safia. Yes, I joined 42 Bedford Row, as it was then, back in 2013. I had moved down from Manchester, where I'd completed my pupillage and started tenancy, and then moved down. And the biggest difference, really, that I found, apart from obviously moving city and circuit, was that 42 was a lot bigger than the chambers I'd left in Manchester. And it is a very large chambers, and it's healthily so, with a number of different teams. But it is incredibly friendly and a really warm and supportive place to work. And I have to say, I haven't regretted my decision to move down either to London or to 42. It's been a brilliant place. Just briefly, I was originally, when I left university and first started out in work, I was working as a radio journalist and then worked as a television journalist. So I was always in broadcast media. And I did that up until I was around 40. And then decided that what I really wanted to do was to retrain. And I had originally been interested in the law and been interested in being a barrister. I'd got a little bit of savings by that stage because I'd been working for a fair few years. And so I had the money to put myself through retraining. And I did the law diploma and then the bar course, both up in Manchester. And then I came down to London and did a master's, mainly in media law, because that was where I felt that I would be most interested in working. But then, as I'm sure you will all either find out or know already, your area of law kind of finds you. And after pupillage applications and seeing where you feel comfortable and where you don't feel comfortable, I began my pupillage up in Manchester in clinical negligence and personal injury. So that's quite a long way from where I am now, which is a housing practitioner. I've been working with housing as my main area of practice for a number of years now. It used to be about half and half between personal injury and housing. But as I say, things change so much in practice. And one of the best things that I think about the job is that it is constantly interesting, and you can investigate other new areas, as well as making sure that you become more specialist in others. So it's a tremendous job, a terrific career. I also work in the Court of Protection area. We are just starting up a team at Chambers in Court of Protection, and there's a huge crossover between all of the teams, from the property side, from the family side, from the personal injury side, because Court of Protection actually involves so many different practice areas. So we're just starting a team up now to try to pull everybody's strengths together. So that's definitely an area that is increasing in Chambers. Housing has been a very solid team for a number of years, but increasingly over the 10 or so years that I've been at 42, it has become a much stronger, busier, vibrant team, and it's a really exciting place to be. So I'm supposed to be talking about a typical week, and I would say that a typical week would probably be about 70% housing work and 30% Court of Protection, and perhaps a little bit of something else that might crop up, a bit of property that I might be asked to do an advice on or something like that. As a senior junior, I'm actually really busy in court, really every day, and paperwork on top of that. The kinds of cases that I'm dealing with are the whole range of work that would crop up in housing, some homelessness appeals, and that can be advice work and drafting as well. And then antisocial behaviour, work in housing, possession, complex possession cases, succession cases, also involving possession issues, and also housing disrepair, which is quite a lively area at the moment in housing law. So generally, my work is in the London courts, so that is good because you get to know your judges, which is really important, extremely helpful when you're being asked to give advice and help the clients before your hearing. You might have a good idea of how certain judges, certain courts are going to be thinking. There are the three main courts in central London, Clerkenwell and Shoreditch, central London, and Mersey Cities. And there's a lot of work in those courts every week. And then there may be some of the other courts that you would go to, but generally my work is very much London based. However, the Court of Protection work can be far and wide, and Canterbury and Maidstone are regular courts that I would visit. I know that other practice areas travel in much greater distances, but those are the places that I would go to. There will always be paperwork every day to complete, so you have to be very organised and very focused, and that can become quite a challenge. So you do have to be prepared to juggle your time and make sure that everything gets done. There will also be regular queries coming through from solicitors, and obviously there must be time found within the day to fit responses to those queries in. So what I would say is that I thoroughly enjoy what I do. You do have to have a lot of stamina, so you do have to make sure that you take some time out to replenish your energy stocks. But it's endlessly interesting. And as long as you find your passion in the practice area in which you get started, which is definitely true for me, you are going to be very satisfied. And just to stress again that the support within 42 is tremendous. I think that works at all levels. Certainly within the housing team, we have regular meetings. We make sure that we have a chat communication so that any question that might get raised by somebody can go onto a chat group, and somebody in the group will pick it up and come up with an idea, suggestion. And so whilst we may not all be in chambers every day, we are very connected. And that is an important strength, I think, within the team. And I'm sure it's reflected in other practice areas within the within chambers as well. But obviously, you have other members to hear from to address that. So I think that is probably all I have to say. And I'll hand over to Safia for the next person to speak.
Thank you so much,
Sorry
Angela.
about
That
that.
was very useful. And hopefully there will, well, if anyone has any questions for Angela, actually, Angela's not able to stay right until the very end of this session. So if you do have anything that you want to ask Angela about what she has spoken about, please do pop a message into the chat box. And I will endeavour to see if we can get her to answer those before she needs to leave us. So thank you so much, Angela, for now, but we might come back to you if
Yes.
there are any questions. Let's hear from our next speaker, and then we can come back and pick up with any questions that anyone has for Angela. So we are now going to hear from Alex Adamou. Alex has joined Chambers fairly recently, but he's going to be talking to us about what a week would look like in the life of a civil practitioner. Alex, over to you.
Thank you very much, Safia, and welcome to everyone. It's lovely to see so many participants, as well as so many questions coming in via the chat and via the Q&A. A little bit about myself first. I was called to the bar in 2017, and I took pupillage in February, March time of 2019. So I am much more junior, and I'm at the sort of 5 to 6 years call mark. Safia is correct. I'm a relatively new joiner to Chambers. I joined in September of last year, but I also took some time to finalise the change and do some paperwork. So I've only really started taking significant amount of instructions with 42 since approximately November of last year. One of the reasons I just very briefly decided to make that change was the environment and the collegiate atmosphere that 42 offered, as well as the type and areas of work that I was exposed to, or had the opportunity to be exposed to. And I must say, from a very brief stint so far, it's been a decision very well made. Everyone has been very welcoming, very delightful to deal with, and it's been just a generally great decision all round. But in terms of what I've done, I'm at my level, or in my practice, I'm what many people would consider a jack of all trades. You name the area of law, and the odds are I've probably done it. My pupillage was with a common law set just outside of Gray's Inn, and I started doing the big three: criminal defence, family, both public and private, as well as all forms of civil, whether that was personal injury, housing, property, court protection, you name it. Even and now my practice has blossomed into a property, a business, and an employment practice. So I'm in the process, as many young barristers do, of starting to focus the areas of work that they do, as well as narrow and start to explore particular specialisms. And I want to get away from what some may consider sort of the more cliche answers, the no, every day is different, you're always doing something, you need to be ready, and give you very much an experience of what the reality is for me on a weekly basis. And that is obviously going to be different depending on practice area. When I was doing criminal defence, it was very much early morning to court, and I was in court 5 days a week, every week. Now that I'm doing more property and employment work, there is a lot more advisory paperwork that forms part of my practice. And as such, I'm not in court every day, but I am still in court 2 to 3 times a week. And as a result, there's the balance is always going to be slightly different. But the reality is, if I could sum up what a week for me is like in one word or one sentence, it would be unfortunately, I'm always on my phone. And that is the reality of life at the bar, particularly in civil litigation. You're dealing with cases that are often long running. They're often, at least in my experience, when I work with various solicitors, they instruct counsel with a view to having that counsel on for the entirety of a particular litigation, not just a single hearing. And as a result, you are often in telephone, email correspondence with those that instruct you, getting updates, taking further instructions, whether that be drafting various pleadings for hearings that are coming up, are they skeleton arguments, whatever that happens to be. You are then in a position where not just the new instructions that are coming in, but instructions that are already underway, already under pieces of written work. You may be asking questions, you may be updating various bits and pieces. And I find that that is a very key part of my work on a daily basis. It's all about communication. It's all about correspondence. It's about being available and almost sort of trying to snuff out problems before they appear. I found it doesn't help when you get to a hearing and you are asked a question. For example, even yesterday, I was in Willesden on a possession matter, on a forfeiture case, and the judge very properly asked me a question about service. Had the defendant been given the papers they needed? Thankfully, as proper, I'd taken instructions from those that instruct me and I had the answer ready. It wouldn't have looked very good if I'd have said, sorry, Judge, I now need to go and ask that question. The response would have been, well, you should have done that earlier. So my week consists of a lot of correspondence, a lot of communication. More often than not, there is paperwork involved, and that takes up a lot of my evenings, especially on court days, because you do have to manage your time and fit your time around your other commitments. And that is not just having a work-life balance, but obviously the work that you take on. And that's one of the great plus sides and benefits of a career at the bar is you are in control. Obviously, it is a bit of a double-edged sword, because when you are in control, there is always a risk that you take on too much. And unfortunately, I'm one of those people where I find it very difficult to say no, particularly to something particularly interesting or a niche or a new area of law. When you're not researching or in communication, I do spend my time at court. And one thing I want to impress is that upon those that are listening, is that part of my week, or a good part of my week, is the travel, for example, to and from. You've heard from Angela about how a lot of her practice, or a majority of her practice, having moved from Manchester to London, is London or centrally based. I happen to quite like traveling, but for some, they may not necessarily like it in the same way I do. But I get instructed all over the country. For example, I've recently concluded a court of protection case that I was a part of that was based in Hereford. And we were dealing with very vulnerable individuals, which meant they could not travel. And they needed the court that was closest to them. And that meant every 2 or 3 weeks, I would do the 3 to 4 hour drive that is to Hereford County Court. I can also say that I've got a hearing, I believe, next week in Birmingham. And I believe I'm then up in Leeds, I think, the week after, whether that remains in the diary or not. So there is a lot of travel around, and whether that means it's via car, via train, or whatever that happens to be, you have to factor that in. because you have to factor that in when you take on work, when you realize how much time work and prep is going to take, as well as you have to be ready you have to be prepared so that when you are traveling, when you arrive, you are ready to go. For many, the opportunity to be on the train does give you that little bit of extra time, whereas if you drive, you may not have that. The final point I would just say on this point, on this topic, so to speak, is that when looking at what you're dealing with, it also, and it very much relates to the earlier point that I raised, is about your area of practice. And it's rather interesting example that I've dealt with recently is that I've been instructed to deal with a number of very urgent injunctions. Now, obviously, in some circumstances, when you've been instructed on an urgent matter, you have to be flexible. And that's one of the key elements of my week, or what life in a civil practitioner is like on a weekly basis, is being flexible with your time, with your commitments, and being able to juggle and manage those. Because when I was instructed on this matter, it was we needed to get this injunction into court today or tomorrow, which meant was I able to effectively drop everything and attend the High Court and wait and see if a judge could hear us. And that meant that I did. I was in court from 9 a.m. till 5 and we didn't get seen. But the point was I needed to be there. The client needed me to be there. And you have to be able to roll with those punches, so to speak. So I want to make sure I'm not rambling too long. I appreciate barristers often get criticised for taking too long to belabor the point. But if I was just to summarise, I would be saying that a week in the life of a civil practitioner, it is one of flexibility. It's one of generally court work and paperwork. And it is very much a front-facing position. That is, you are, or at least in my practice, very much sought to be involved in the litigation process, which means being in contact and communication with not only those that instruct you, but also your lay clients, if need be, in contact with your clerks and in touch with other members of chambers, whether that be for support, asking questions, or even sometimes covering and getting an update on matters they may have dealt with before you. And that's really the final point, is one thing that I do every day, or at least I say I do every day, I try and do every day, I'll be a little bit more accurate, is I try and keep in contact with my clerks. At least once a day, I like to try and give a phone call and say, are we all good? What is happening? Because again, it's about keeping on top of your diary. It's your business at the end of the day, and you need to be aware of what's happening and when. So Safia, I hope that's given us sort of a relatively raw reflection of what a week in my life is like. I don't believe I've made it sound all too glamorous, but I'm hoping that's at least a real reflection of what I do on a weekly basis. I don't know how I'm doing for time. I believe I've gone 10 minutes and about 30 seconds. So I may have gone over slightly by about 30 seconds. So do please forgive me.
We'll give you 30 seconds, Alex. Don't worry.
Thank
you so much. All right, let's move on to our next speaker. I have seen that there are some questions that have come in for Angela, but I'm just going to give a bit of time for anyone else who does have them. Angela is still with us for a bit longer. I believe Zoe also does need to leave a little bit earlier than the end of this session. So as you listen to her, if you have any questions for her specifically as well, then please do put those into the Q&A. I think some of you have also been using the chat box. That's fine. We can see both of them, so don't worry. And we will try and deal with all of those before they need to leave us. So Zoe McGrath has joined us. Thank you, Zoe. And Zoe is going to talk to you about life as a family practitioner, but she'll also be touching, I think, on her transition from her former life as a solicitor to now practicing at the bar. So Zoe, thank you.
Thank you, Safia. So good evening, everybody. As you will have heard, I've been asked to talk to everybody this evening because I've come to the bar in a slightly unconventional and different way. So when I was 15, I did my work experience with a children panel solicitor and was immediately obsessed with the idea of becoming a children panel solicitor myself. I definitely like the focus around human beings, why they do things. And I then was quite devoted to that being my professional career. I undertook my A-levels and then decided that I couldn't really go to university for lots of different reasons. And I contacted the solicitor that I did my work experience with when I was 15, and had a chat with them. And they offered me a contract, a training contract as a legal executive, which some of you may have heard of and some of you may not. But it's a different type of lawyer that comes under the umbrella with solicitors who conduct litigation. So I initially qualified as a legal executive, which meant working full-time for a solicitor and going to night school to qualify. I then decided that I did want to be a solicitor, and I was very lucky in that the firm that I was working with sponsored me to do what was then the LPC, and I therefore qualified as a solicitor. And then approximately 3 years ago now, having spent most of my life as a solicitor advocate, I decided to transfer to the bar. So I've actually been specialising in family law, but more particularly Children Act proceedings for about the last 26 years, because I started my career young before going to university. I have the benefit, therefore, having been a solicitor and having worked for solicitors, for knowing what solicitors need from you as a barrister. And that can differ depending on who your instructing solicitor is. Some solicitors are very hands-on. They will tell you exactly what they want you to do for your client in court. Others will want you to drive the proceedings, certainly in relation to Children Act proceedings, and be the driving force in terms of the advice that's given, and really taking a view on what should happen next in the proceedings for the client. So it's important as you develop your practice that you get to know your instructing solicitors and what their expectations are of you. As a solicitor, I specialised initially in all areas of family law. So I would do some finance in divorce, not very much at all. I have always undertaken domestic abuse work and still do that now because that's a passion of mine. But overall, I specialise very much in Children Act proceedings, both public and private law. So for those of you that don't know, private law is, generally speaking, between the parents of children or family members who have a dispute as to where that child should live or how much time they should spend with the other person or family member. Public law is where the local authority become involved because there are, generally speaking, child protection issues, sometimes very significant child protection issues, whereby they feel that children are at risk of physical, emotional or sexual harm. Over the years, I have developed a strong practice in public law, and I would say that now probably takes over probably about 90% of my work is now public law. I choose generally to represent parents or the children themselves through their guardians. I do some work for the local authority, but not very much. And again, that's been a preference of mine that's developed over my career. Chambers as a whole does do quite a lot of work for local authorities. And if I wanted to do more of that, I could. But as I said, my preference has always been to represent parents and the children themselves, which I find quite fulfilling. What you will find as you develop a practice is that there will be certain areas that really interest you and that you want to develop, and other areas that you are not as keen on. The benefit of being a self-employed barrister is that you are entitled to take a view on what you want to do and what you don't want to do, and your clerks will understand what you want to do and what you don't want to do, and they will help you to get that work. As I said, I transferred to the bar nearly 3 years ago. My reason for that was I had spent about the last 10 years working as a freelance solicitor advocate. So I was really doing the work of a barrister, but under the umbrella of a solicitor. And during the COVID years, I was very lucky that I managed to keep my practice going as a freelance solicitor. But I became very aware that as we moved over to remote hearings, that some solicitors were able to do more of the hearings themselves because they could double up on their work, given that they were attending court remotely. And I thought, actually, I might benefit from having the support of a chambers behind me if my practice is going to change. And so for that reason, I decided to transfer to the bar, which was quite a simple process for me because I was already a qualified solicitor with many, many years experience of advocacy. I chose 42 partially because they were one of the chambers that approached me and said that they thought that I would be a good fit for chambers. And I think that was right. I knew quite a lot of the barristers in chambers, and I thought that they would be a good fit with me and my practice. And also my instructing solicitors. It was a chambers, certainly that the firms that I worked for would instruct. So that was obviously sensible for me as well. 42 as a whole is a very supportive set. You've heard from others. There is a family group WhatsApp, so we can, any questions that come up, any oddities in your day that you may not have addressed before or come across before, you can put it into the WhatsApp chat and someone will have dealt with it before and will be able to give you some advice. We also have excellent clerks that have really good relationships with instructing solicitors, which is really key, I think, to everybody developing their practice. And overall, we have really good quality work. So the type of work that I do now, I have lots of cases where there's non-accidental injuries of children. So they've suffered an injury with their main carer that medical professionals believe was probably inflicted. And so we have trials to determine who was responsible for causing those injuries. And then after that, in the children's welfare interest, where should they now live? So that work is complex and it's something that I enjoy. And there's a wealth of that work in chambers. There's also lots of work at the more straightforward end. So as you're starting to develop your careers, injunction work, simple private law cases, lots and lots of work. So you'll be able to suss out what you want to do, what you like, what you're good at, what instructing solicitors like you, what's the work they want you to do. And there's so much work there that you can easily develop a practice. What I found when I transferred to the bar, which I wasn't expecting in some ways, is how work is allocated. And I think there's been some questions about allocation of work and allocation of fees. Obviously, you are a self-employed barrister, so you have to a degree, create work for yourself by developing relationships with instructing solicitors, by, if you go to court for a new solicitor, and indeed all of your existing solicitors, you need to do a good job. You need to communicate with them. You need to make sure that you've done your attendance note, make sure they know what happened and what the next steps are. So that's your part. You hope then that the solicitors will pick up the phone next time they have a case that they think that you will be good for and say, is Zoe free on X date? Can she do this? And I was aware that that was going to be something that I would need to do prior to transferring to the bar. But what I hadn't quite appreciated is, of course, there's those days where you have a gap in your diary and an instructing solicitor will contact your clerks and they will say, who do you have free on the 3rd of February? And they'll be given a list. So your next responsibility whilst you're trying to develop a practice is to be the name that they choose from that list. And again, that goes back to being professional and making sure that you are providing a good service to your clients and to your instructing solicitors. The benefit of being in a chambers like 42 is that there is a wealth of work. There's very good relationships between chambers and solicitors, and that obviously pays dividends for individual barristers working within the set. So I'm also going to talk to you about the average week for a barrister like me. You've heard the cliches already. There's no 2 weeks the same. Nothing could be truer than that, especially as a child practitioner. Sometimes you'll have a very long hearing. It might be 5 days long, it might be 10, 15, a month, 6 weeks. When you start life at the bar, the thought of doing a 6-week trial is quite horrifying. You think, how on earth am I going to deal with this? Actually, once you are up and running and you are experienced, that can sometimes be much easier because you are just focusing on that one case predominantly for a period of time. And there isn't other responsibilities that you are having to do on a daily basis. Most of the time, when you don't have a long trial, you will be in court every day on a different matter. So that means receiving papers, reading those papers and understanding all of the key points from them, and then attending court for a case management hearing where the court will then decide, make directions as to what evidence is required to bring that matter to trial. Within Children Act proceedings and child protection, there are often urgent hearings that you are instructed on at very last minute, and I had one of those today. So this morning I was in Central Family Court dealing with a case that's going to be ready for trial in about 3 weeks' time. I had just come home, was preparing my attendance note to let the solicitor know what had happened, and I received a call to say that I needed to attend a different court remotely at 3 o'clock for an urgent hearing. I was then sent papers that I had to read very quickly, had to have a telephone call with the client to ascertain their instructions, and then I was on screen representing that client on an urgent hearing. This afternoon, I've then had 2 advocates meetings. So before case management hearings, you also have something called advocates meetings where the lawyers get together remotely, thankfully nowadays, to talk about the issues in the case, what can be agreed and what's going to be disputed before the judge. So in an average day, you will generally be in court during the day. You will certainly have papers to read. You may have urgent hearings that you need to deal with. And when you are busy, you will also then have advocates meetings that tend to take place in the evenings. From 4 p.m. to, as I have this afternoon, 6 p.m. This evening, because all of the advocates were busy until then. So you certainly have to be flexible if you're going to be at the family bar. But the benefit, I would say, of being at the bar over and above being a solicitor is that you do have control over your own time. So, for example, if I know that I'm free in an afternoon and I have something that I need to do, I can go and do that. But then I know I then have to work in the evenings and do my reading and my prep for my trials in the evenings. So you do have to be very organised. You do need to enjoy reading, because there will be a lot of reading involved, I think, in any area that you practice, but certainly in relation to child law and family law. And there will be variations as you become more experienced in the types of hearings that you are covering. In addition, as has been said by the others, you will also then have paperwork. So you will have emails from solicitors saying, this has happened on a case, what do you think we should do? Or we need an independent social worker or a psychiatrist. Do you think this is the right psychiatrist for this case? And you'll be asked to consider CVs. And there'll be occasions where you're asked to prepare skeleton arguments on complex areas of law or advices for leading counsel or various other things. So there's always paperwork. At the family bar, that's very rarely the main focus in terms of how the time that you have to allocate to that. It's generally something that you have to fit in around your court work, unless you're incredibly organised and you ask your clerks to mark time out of your diaries so that you can do that paperwork. I'm not very good at that, but I'm learning. So that's my general week and how I came to be at the bar. I think it's time now for me to hand over to the next person, and I will be able to answer a few questions once everybody's finished, if there aren't any questions specific to me, before I have to leave at about 6 o'clock.
Thank you so much, Zoe. I think what we're going to do is, rather than hear from Matthew now, I think we might pause and take some questions that have come in, Angela, for you and for Zoe. just so that we can make sure that we can conclude those before 6. I'm conscious that if we have the next presentation, we will be potentially slightly tight on time. So, Angela, when you are able to join us, oh, there you are, thank you. We've had some questions for both of you, so perhaps we'll deal with those now and then we'll move on, particularly because Matthew's going to be talking about life as a very junior member of Chambers, and then I'll be talking about pupillage, and we've had lots of questions about the pupillage process, so thank you for those, and I will try and do my best to answer as many of those as possible in the course of my own discussion on that. So let's take some questions then for Angela first, if you don't mind. I'm just going to scroll through and find the ones I had highlighted. So, Angela, we've had a question about your shift from Manchester to London, and you're being asked what the differences are between the circuits and what you found most surprising about that shift.
Well, the decision to move from Manchester to London was a difficult one. It really came about because I've been living and working in Manchester for 20 years, and all of my family were down south, and it just got to the point where I wanted to be closer to my parents and sister. But also, in the chambers that I was in Manchester, I'd had a very good friend called Iris Ferber, and she moved to London a year before me, and she moved to 42. So we were having the discussion about moving, and she suggested perhaps making an application to 42. So I already had that very good, strong link with Chambers, and then was invited for interview and met, because it was my application was civil, Richard Furness and some other members of the civil team, and so the rest is history, as they say. So that is how and why I came to be at 42. And the differences between the North and the Northern Circuit and practicing in London is, I would say there was so much travelling right across the Northwest for a start off. So there was a lot more travelling, and I tended to drive everywhere then. So that just the general pattern of my days were quite different. There's a lot more focus because on circuit, on bar mess, and being a member of circuit, and I haven't joined in with any kind of circuit or in life in London, so that was a big difference as well. And I would say I've probably the biggest difference is that I have forged much stronger relationships with my instructing solicitors. Why, I don't know. Maybe it's just that the area of law sort of suits me better, because I was doing more personal injury up in Manchester. But I just generally feel that I'm working with people a lot more rather than having receiving instructions. So it's lots of positives, basically. I think that covers that one. I'd seen one about the Court of Protection, about what that is, and I just wanted to say that's about dealing with protected parties, people who don't have capacity to make decisions for themselves in terms of their welfare or their property and affairs. So you're dealing with people who have got, can be quite ill, and don't have capacity, or people who are well and don't have capacity, but everything has to be in the person's best interests, and the two branches are welfare and property and affairs. It's really a very interesting area of law and completely different to housing.
Well, on that point, Angela, we've had a question that says, what attracted you to a housing practice, and why has this become an area that you've continued to practice in?
Well, one of the reasons, I suppose, why I was interested was because between finishing my master's and securing pupillage, I worked for legal practice clerks. And I know that many people who are applying for pupillages may have also had some experience working for LPC law as it is now. But I worked for them up in Manchester and did a lot of credit hire and possession works, mainly in mortgages, I think, at the time. And so I was familiar with that area. So when I was at Chambers in Manchester, as I say, my pupillage was in clinical negligence and personal injury. But there was one person who had completed his pupillage just before me, and he'd been working with the Roundtree Trust before he joined Chambers. So he had a strong area in housing law. He wanted somebody to be able to pick up work when he wasn't available. And because I'd got a grounding in it, it was a no-brainer really to say yes. And I think just generally it just has everything. It's about real life. Everyone needs somewhere to live. People need good quality housing. At the same time, local authorities need to manage their resources. So there's that balance of trying to work out, how to deal with that. The law is always interesting and changing, particularly homelessness law. So there's something to satisfy everything. Basic interest in looking after everyone's basic needs, and also, really ferreting out answers through case law and legislation and arguing a point. Lots of paperwork, drafting, particulars of claim, defences, skeleton arguments, as well as advices to solicitors, and then lots of advocacy in court. I mean, it's just got everything.
Thank you, Angela.
You do
Zoe.
have to be flexible, I would.
I think that applies to every area, to be fair. I don't think it's specific to any one person or any one level of call. So thank you so much, Angela. Zoe, let's move on to some questions that have come in for you. What drew you to children proceedings in particular?
I think very similar answer to that Angela just gave in relation to housing law. It's about real life, and it's about people, and it's about the most vulnerable people in society generally. So children law covers a real spectrum of issues, mental health issues, housing issues, domestic violence, education sometimes, psychological difficulties, personality disorders, autism, learning difficulties, every vulnerability that you can possibly think of that a person might experience will generally be a factor within Children Act proceedings. And it's that drew me certainly to it. I was going to say earlier, because I think that I saw a question about if you don't want to do a particular area of law. I've only dealt with family because of the way that I came to the bar. And as much as I love it and would not want to not do it, I think that there are certainly merits to, when you are coming to the bar, when you're doing a pupillage or when you're training, having the opportunity to look at lots of areas, because you will find interest in other areas that you don't even know exist. So don't be too single-minded. I certainly wish I'd had an opportunity to look at some other areas, albeit I certainly don't regret my decision to specialise in family.
Following on from that, then, we have another question for you. How do you separate yourself from the emotional elements of the family cases that you do?
That's a really good question. I'm certainly somebody that will cry watching Call the Midwife, so I understand why people worry that they would find it too emotional. But you're actually You're there to help. You're there to serve a specific function, which is represent a particular person's interests, with the welfare of a child being the overriding factor. And you're going to approach it differently to if this was your friend or somebody very close to you. You're thinking about, what's the evidence for this? What does this child need? What does this parent need? How are we going to get it for them? Is there evidence to support what's being said about this person? Or is this something that should be chucked out as an issue? So your focus is very different, and that tends to remove you from the emotion of it. Obviously, there are times when you're in court and somebody, a parent or a child sometimes, is giving evidence, and that's very difficult. But again, you have a different hat on. You're listening to that evidence in your professional capacity to think about, what do I need to do with this evidence? What question do I need to ask next? Or what do I need to ask another witness about this? So it tends to engage a different part of the brain. And I think that makes it easier than to manage the emotional element of it.
And then finally, we've had a couple of questions about your transfer from being a solicitor to coming to the bar. So I'll ask a couple of these now, and then you can answer them together, because I'm sure that will probably be the easier way of dealing with it. So one of them was, did you want to take pupillage, or did you apply for a waiver from the BSB, given your experience? And then the other question was, if you had rights of audience as a solicitor equivalent to being a barrister, why did you transfer to the bar?
Okay, I'll take those in reverse order. So barristers don't have the same rights of audience as solicitors, or rather the other way around. So solicitors do have automatic rights of audience up to the High Court, but you don't have automatic rights of audience to appear in the Court of Appeal, and that's as Silex and as a solicitor. So you do have slightly different rights of audience. You can, as a solicitor, do an additional course to gain higher rights of audience to enable you to appear in higher courts. And lots of solicitor advocates do that. The reason I decided to transfer to the bar rather than stay as a solicitor is that they are different roles. So as a solicitor, yes, I got to be in court, and I was very lucky that solicitors would just instruct me to do advocacy, and I didn't have a caseload for the last 10 years of my life. But they are very different roles. It's not easy all of the time to just have a pure advocacy role as a solicitor. Many solicitors will want you to have a caseload as well. Whilst I enjoyed being a solicitor, my skill set and my passion for advocacy really always took me, down the court route. And I know my secretary used to say, please somebody send her to court because she's driving me crazy when I was in the office. So it is a different role. I think as a barrister, I have found, and I don't know this is just for me or other people, I get better quality work. So people trust me more as a barrister to do the more complex cases. So I've had a lot more work with non-accidental injury and cases like that since I've been at the bar than when I was a solicitor. So I think that has been an overriding factor. And generally speaking, the reason we all go to work is to make money, and you will make more money, probably, or certainly in my experience, as a barrister than you will as a solicitor in any capacity. So that was that. Have I answered both questions? I feel like I haven't answered the second question, and I've forgotten what it was.
So the second question was about whether or not you had to complete pupillage, or whether you had applied for a waiver.
Yes. So yes, I applied for a waiver. So generally speaking, for anybody that this may be relevant to, the Bar Council will grant waivers. As a solicitor, they more often than not do actually want you to do a pupillage of some kind, usually 6 months, so you're already on your feet, but they do require that pupillage. And that's because you have had to have a caseload and be in court. So you haven't had that 24/7 experience of what life is like in court all day, every day. Because I had worked as a freelance advocate with no caseload for over 10 years, they gave me a full waiver. So I just transferred to the bar and I didn't have to do a pupillage. But many solicitors, even very experienced, and somebody who was a partner in the firm that I worked in, when he transferred to the bar, he was also asked to do a short pupillage. So there is that expectation. It's very much case by case and what you can persuade the Bar Council of in relation to your expertise and your experience. But I didn't do a pupillage.
Thank you. Thank you so much, Zoe. I think those are the questions that were specifically directed at you. So we can let you go. We're now going to hear from Matthew Timm. Matthew is one of our newest members of Chambers. He completed his pupillage in Chambers and that ended at the end of September last year, I think, Matthew.
Yeah,
so
that's
he's
right.
been attendant for only a few months, and he's going to be talking to you about the transition from being a pupil to being a tenant and what life is like for a very junior member of Chambers. So over to you, Matthew.
Thank you, Safia, and thank you everyone for joining. Just a very brief background. I studied law at Newcastle University, and that was after I did a mock trial when I was 13 in high school and realised just wanted to be a barrister. And so ever since then have taken every opportunity to get experience in law, whether that's through pro bono, being a paralegal, and before pupillage, I was a research assistant at the Law Commission. I then studied the bar course in London and then started pupillage in October 2023. And as Safia mentioned, I've been a tenant now for around 4 months. And so looking at pupillage, it's divided into 2 6 months, which is known as the first 6 and the second 6. And so dealing with the first 6, that's a really exciting time because you are shadowing experienced supervisors on some really interesting cases, and you really are just following them around every day, going to court with them, and you get to see some really amazing advocacy in really interesting areas. And so one of the reasons I applied to 42BR is because I wanted a mixed practice and I wanted to try lots of different areas, and I really got to see that in my first 6. So some examples in family, it was the public law care proceedings, which Zoe has explained, particularly non-accidental injuries to babies and young children. I did some employment, which was really interesting, looking at issues of unfair dismissals, lots of disability, which are really are complex and difficult areas of law to get your head around. I also did personal injury, and one highlight was it was a tourist diving boat in Egypt which set on fire, and sadly some tourists were killed. And so we were looking at whether a claim could be brought against the travel operator in the UK. And so they were really interesting cases where I was both in court a lot more with family and employment, whereas the personal injury was a lot more paperwork based. And so the work I was doing, there was lots of research for my supervisors. Often I would draft pleadings, particularly in personal injury. And otherwise, more so on the family side, it was preparing for trial. And so I would have the first draft of a position statement. I would send that to my supervisor, who would look over it and give me feedback. In employment, I prepared lots of cross-examination questions. And then after seeing my supervisor do it in person and how good they were, I learned how to improve and how to really focus on my questions going forward and what really were the issues. It probably went from about 10 pages down to 2. So that was a really helpful exercise. And also things such as closing submissions. I remember drafting just a short section in family proceedings on if someone is lying, what the court can infer from that. And so first 6 is a really enjoyable experience at 42BR because there's no formal advocacy exercises. Instead, you do lots of different pieces of work where you're given feedback after every piece so that you can improve for next time. If something's not quite right and it needs some work, you have another attempt so that you can show improvement. But it's really about a friendly, supportive environment to make sure that you have the tools needed to succeed, and for you to ask as many questions as you can so you can learn from some of the best members of Chambers who are really at the peak of their career. In addition, there's a great work-life balance. I worked from 9 until 6 when I was in Chambers. Otherwise, I was with my supervisor going to court, and I rarely worked in the evenings and had weekends to myself. And really, it was just an amazing time to ask questions and to learn, which then brings me on to second 6. This was the biggest jump, and that was super scary because it's finally your own cases. And so it's really daunting because for the first time you have a client, you're given instructions, and you have to appear in front of the judge and present your case, and you get a real judgment. And so it's a really nervous time, but everyone in chambers is fully aware that you're about to start. And so everyone's really friendly and supportive. And there's three really good things about 42BR that made me feel really prepared for my second six. The first is the clerks. They started really slow and made sure that I had enough preparation time in my diary. So I probably had 2 or 3 cases per week. And it really allowed me the time to read the textbook on the relevant area, to make sure that I knew what I was doing, and to just have enough time to almost recover after, because it's so intense when you're first getting started. Second, as every speaker tonight has mentioned, it's a really friendly set. And so the juniors in chambers were always willing to talk and explain and help me. The fact that it was my first time, and just explain the procedure. But it also went right up to the KCs in chambers, who were willing to have a cup of tea in chambers, explain things, talk about how they would approach a certain issue. And that was really helpful to hear from lots of different members of chambers, no matter how senior, to make sure that I really understood what I was doing. And third, you have a supervisor who's always available for emergencies. I called my supervisor many a time, especially with ethical issues. And so an example was whether a party had capacity to conduct litigation. It was an old person in a residential home, and it had never come up before. I didn't know what the rules were, and it was what to do. And so called my supervisor, who was really helpful in that situation. In terms of the balance of work in my second six, I would say roughly 50% is housing. And so that's mostly short possession hearings. They're short, it's 10 minutes, and it's black letter law of looking at the relevant Housing Act. And either you have made out your ground for possession and a possession order is made, or you haven't, and the court has to set down directions on what should happen next. I also did a lot of civil applications, so that's things such as strikeout, relief from sanctions, directions hearings, and also I reckon about 20% was preliminary family or employment matters. So a real mix across all of Chambers practice areas. And I loved it. It was great fun and a real thrill. For example, for the first time, got to actually cross-examine a real life witness rather than it being an advocacy exercise. And so I had a bus driver who was involved in a road traffic accident, and mysteriously the CCTV had gone missing. So I got to say that he was lying and he had caused the collision. And that was a real thrill, especially when you get the judgment from the judge and they say that you made a really good submission. It's really rewarding. And after so many years of doing different jobs, such as a paralegal and pro bono and all of that, you're finally on your feet and doing your own cases. And so after all of that, after the 12 months, so you've got your 6 months of first six and your 6 months of second six, where you have your own cases. My practice now really is just an extension of second six. There isn't the same jump. Instead, my cases have just carried on, and my diary has just got busier. And so in terms of the work, it's very similar. That again, I'm doing a lot of housing work. That's the majority of my practice. Also a lot of personal injury, so those road traffic accidents that I mentioned. In addition, I'm doing some more employment and family. And so I had a really exciting opportunity where I was led on a family case, which was a public law care proceedings case, where unfortunately the mother that I was representing with a more senior member of Chambers, there was issues of domestic violence, drugs and alcohol. And the question was whether her 2-year-old daughter could be returned to her care. And so that was a 2-week case that I got to be led on. And it was absolutely fascinating. Lots of factual witnesses, expert witnesses, and lots of difficult issues to deal with. And so on average, I'm in court 4 or 5 days per week. In addition, I have 1 piece of written work on average per week, and that will usually be pleadings or a piece of advice. And it's a really interesting time because you're finding your feet of what you do enjoy and what you don't enjoy. And you're also just trying a lot of things for the first time. And so often I'm reading a textbook the night before on how a certain hearing works, and then get to give it a go. And so I'm really enjoying it. And you have a practice review meeting with the clerks where you can say if there's certain areas you want to try more, if you really enjoyed something. But otherwise, I think it's good to have an open mind, and particularly for me, coming to 42BR and the fact that they have specialisms in so many practice areas, it means that I have a really diverse week. Each week is different. I'm trying lots of different areas and just giving it a go. And so I'm still very much learning, saying yes to lots of things that come into my diary. And overall, it's been a brilliant experience where I really have learned so much from all the different members. And I can't stress enough how much it's a friendly set, that any issues that now crop up in my practice, it's almost an extension of first and second six, that I still speak to my supervisors, I still speak to the juniors, and there's always someone on hand if I come into an issue. So I really encourage you to get your applications in, because it's a great set if you have lots of different interests, or you're not quite sure exactly what it is, what area you're wanting to practice in, and you want to give it a go. So I look forward to hearing that many of you have applied from this evening.
Thank you so much. That's a great way to bring the specific discussions to a close. I'm going to be talking to you about pupillage with my head of pupillage hat on. I've seen there are lots of questions about pupillage and the pupillage process, so I'm going to try and answer some of them as I go through, and if I don't get through all of them, I will then try and go through some of the additional questions at the end. I can also see that we've had lots of questions of a more general nature, and some specifically for Alex and Matthew. So we will try and get through as much as we can before 6:30, although I can say, looking at the number of questions that we have, we might not get through all of them. But what I will say from now is that if we don't get a chance to answer your specific question, and you are very keen to get an answer, then please do send us an email and we will try and come back to you. So, in terms of the pupillage process, we've had some questions about the application forms and about the interview process, so let me talk about that. So first of all, Chambers follows the gateway. So you will apply through the gateway following the timetable that is set out there. We don't take applications outside of that process. In terms of the form itself, we've had questions saying, can you give us some tips on how to complete the application form? In particular, we've had some questions that say, well, how do we recommend that you incorporate your interest in 42 within that? There are opportunities, of course, within the form for you to talk about what you're interested in, why you're interested in Chambers. So please do make the most of those opportunities. But in terms of additional tips, I think the most important one, and I say this pretty much every year, so if you haven't already, you can go back and look at the sessions like this that we have undertaken in previous years with different members of Chambers, so you'll get a different flavour of how other members of Chambers practice look like. But you may hear this same point, but it's one I keep saying because I think it is so important, and it's one that so many people often miss out, which is that when you are talking in your form about your experiences, particularly your legal experiences, but even if you're if not with your non-legal experiences, please do make use of the box that allows you to talk about what you saw and what you learned, and tell us a bit more other than just, I went on a mini pupillage and I saw a family case full stop, because actually a number of people do that, but you miss out on the opportunity to tell us what you learnt, why you thought it was interesting, and something that gives us an understanding of how you benefited from that experience. So please make the most of those opportunities to tell us things which you think are going to be important. We get asked a a variation of this question every year. What's the one thing that you think is important in an application form? What one trait do you look for in an applicant? And I'm very sorry that I don't have a simple answer to that question, because the reality is we're not looking for one particular thing. Equally, we're not looking for one particular type of person. What we are looking for are people who are going to succeed at the bar, people who are going to succeed in the practice areas that we specialise in, people who are going to fit into the supportive culture within chambers, people who are proactive, people who are going to support themselves with the support of chambers, of course, to build a practice, to develop themselves and to support others, so that ultimately they are succeeding in their own right, but they're succeeding also as part of a team. And that's essentially what we're looking for. But how that comes across, what particular traits people have, it's not as simple as saying there's one thing. And actually what we're not looking for identikit people that says, well, actually, you know, we want everyone to be the same. We're looking for people who can add value, and you can add value in so many different ways. So please, when you are completing that form, don't assume that you have to conform to a particular type in order to succeed in chambers. You don't. What we're looking for is authenticity. Be authentic to yourself. If you have particular interests, tell us about them. If you really don't like something and you think it's important that we know that, tell us that too. Make sure that you are true to yourself, because the reality is you can fill out a brilliant form that you think meets the criteria that we are looking for, even though that might not be you. But when we invite you to interview, it's going to be pretty difficult for you to then maintain that facade when you're actually being asked questions by us. Whereas if you are authentic in your form, and then we meet you and we can see that authenticity, then you are going to give yourself a much better chance of success. So, having completed the form, we then review all of those forms, and there are hundreds of them, unfortunately. But at the end of that review process, we will select about 20 or so applicants to attend chambers for a first round interview. Now, that interview is fairly short, probably no more than about 10 minutes or so. And what we're really trying to do in that short interview is to get a flavour of the type of person you are. Oh, excuse me. My phone was on silent, but it's managed to get through on my computer screen. So going back to where I was, in our first round application process, we are looking to see what kind of person you are, how you fit with your application form, and essentially get a flavour of a bit more about you, because obviously the forms are quite limited, and we feel that it's important to actually meet more applicants than we necessarily can interview in more detail. That allows us to then, from those 20 or so people, and it might be slightly more or slightly less depending on how we end up shortlisting, we will then review those interviews, and we will call a subset of those, and the exact number varies from year to year, and it sometimes depends on how people do and how many people we think are worth interviewing again. But we will then call a slightly smaller number to a second round interview. Now, the second round interview is much longer. We will give you a question half an hour before your interview starts to think about and then discuss with us in that interview. And we will also look at some ethical questions. We'll have some more general questions for you. And that's also an opportunity for applicants to ask us any questions. And Following that, we will then decide who we wish to make offers to, but of course we will hold off on making offers until the window for making such offers opens via the gateway, and we will then get in touch with those whom we want to make an offer to. So that's the sort of bare bones of the process. Let me just go through some of the questions and deal with those. Somebody's asked whether it's possible to apply to chambers when they're only interested in civil law but not family. And this is a good question, which we're often asked. So as you will know from looking at Chambers' website, and if you haven't looked at it, please do, it's important that you have an awareness of the variety of work that we do. But we fully understand that not everybody will necessarily be interested in every single area that we practice, and we don't expect that. So if you have an interest in a particular area that we do, that's absolutely fine. However, what I would say, and I think this is something that Zoe mentioned earlier as well, we do encourage our pupils to undertake work in both civil and family work during their pupillage and right at the very beginning of their careers as tenants. And the reason for that is because each area of practice will assist you in developing different skills. And it's really useful as a very junior member to have that variety of skills before you potentially specialise into a particular area. The other advantage is that there may be areas of work that we undertake that you have not necessarily experienced before. You might think that you're not necessarily going to enjoy them, but that might not be the case. And there have been in Chambers examples of individuals who have come thinking that they want to specialise in area A, but having been exposed to area B, they suddenly find that actually that's something they're more interested in. So what we would encourage you to do is to keep your options open. Obviously, we understand that people do have particular interests, and that's absolutely fine, so long as you are not entirely closed off to a particular area, because you may find that there are skills that you can benefit from by practicing in that area, even only for a short period of time. And that's the same also in terms of interests during pupillage. And we've had another question about that in terms of how a supervisor is allocated, which areas of practice do you spend time within. What we try and do during the first 6 is to ensure that you spend 3 months doing some family work and 3 months doing some civil work. And particularly within the civil arena, we work with our pupils to make sure that we take into account areas that they are interested in and give them a supervisor who specialises in that area, or at the very least for them to spend a significant portion of that 3 months undertaking that particular area of work. So there is flexibility within pupillage to take account of your interests. But equally, as I say, it's helpful for you to see that variety and to learn and benefit from people who practice in different areas. We've had a question about the application form question relating to when people are free to start pupillage. So this year, somewhat unusually, we are advertising for 2 pupils to start in October 2026, which is the usual rotation for applications. But we also have a space for somebody to start in October 2025. So the question that asks about availability is simply trying to ascertain whether you are applying for 2026 only or 2025 and 2026, and of course you can apply to be considered for both. So that's really all it is asking. In terms of, I think I've answered questions about application forms. Let's see, I think there were a couple of others. Just bear with me whilst I scroll down. Yes, we've had some questions about applying from abroad, visas, and also waivers. So let me deal with those. In terms of applications to chambers, yes, if you do need a visa to complete your pupillage, that isn't a bar to applying to chambers. And if you were to be offered a pupillage, then chambers would support you to deal with the visa application process. So that's not an issue at all. And equally, in terms of waivers, if you have a waiver of some description, and as you've heard, there can be variations in terms of how much of a waiver people can obtain, then that isn't a bar in any way to applying to chambers. So please don't let that stop you either. I think the question also asked whether there was a reluctance to offer tenancy to people who had been awarded waivers. That's not an issue. And I think the simplest way of explaining that is to point to Zoe's own explanation in terms of how she joined chambers. Clearly that wasn't an impediment at all, even though she had a full waiver, and chambers was very keen for her to join. So that's not a problem at all. Yes, mini pupillages was the other thing that came up in the questions. So Chambers does offer mini pupillages, and there is a lot of information on our website in relation to those. We offer a number of mini pupillages on a 3-month application cycle. So essentially you apply by a particular date and then you can be offered a mini pupillage within the next 3 months. And we run those throughout the year. So there are 4 cycles for that. We do encourage people to undertake a mini pupillage within chambers, simply because that's the best way before applying to get a sense of what chambers is like. But it's not essential. And if you have not completed a mini pupillage in chambers, that is not a problem at all. However, I would say on the point of mini pupillages, we strongly encourage you to complete at least a couple of mini pupillages before you apply to us, and indeed I'm sure the same would be for anywhere else, simply because if you haven't completed any mini pupillages, it's very difficult for you to really understand what the role entails, and it's inevitably going to make it more difficult for you to be able to explain why you want to come to the bar, why you think you'll succeed, and for us to be confident that you really understand what you are applying to do. So we would strongly encourage you to undertake mini pupillages, whether that's with us or somewhere else. We don't assess our mini pupillages, and we don't require you, as I said, to have undertaken one. But we do feel that it's important that you get a flavour of what life is like. So please do apply if you are interested in a mini pupillage in chambers. Right, I think I've dealt with the majority of the pupillage related questions. If you have any other questions, or there are things that I haven't covered, then please do drop a question in the box. But I'm also conscious that we don't have much time left, and we do have questions that have come in for Alex and Matthew. So if you are both there, please do rejoin so that we can deal with those questions. So perhaps, Alex, if I can ask you, there have been a couple of questions that have come in about your practice and the variety in your practice. So let me just ask a couple of these and then you can answer them together. One of them was, what do you enjoy most about having a business law practice in chambers? And then there was also a question about the overlaps, if any, between employment and property practice.
Yes, well, let's answer those in the order they've been asked. What do I enjoy about a business practice? Well, I must admit, one of the things that I enjoy is that it's in areas that I'm very comfortable. I like working with numbers, I like working with mathematics, and part of a business law practice is you, to a certain extent, have to be very much up to date with how things are calculated, how companies are run, for example, how to look at, for example, a balance sheet. Those sorts of things are things that you learn and you get to deal with, but they're things that I have always enjoyed, not enjoyed doing, but I've been very good at doing and I've been very comfortable doing. Another thing that I enjoy about business in practice is actually very similar to answers that you've already heard, is that you get to see a real impact in how things work. And it also, one of the things I really enjoy about business practice is by doing my job, being able to advise companies and the learning and the research I undertake to be able to do my job, I find I'm able to look at things that happen in the world, understand what happens in the world, and think a little bit more deeply about things that happen in the world. So when you see news stories about inflation rates or interest rates going up or down, or what the Bank of England might be doing, all of those economic concepts, how the world necessarily functions, what drives people, economic actors, being able to understand those factors allow me to become a better advocate for those that I represent, because I can understand my clients, particularly corporate entities or individuals with private businesses or sole traders. I can understand their perspectives. I'm not necessarily in a position where they're talking jargon at me and I then have to go and look in the dictionary about what they're saying. I can give real-time advice because I understand what they're talking about. And then, as I say, it's almost a feedback loop, because then the more experience I have in working with companies and helping them with their problems, the more I can sort of go, okay, well, why, for example, are these corporations unhappy about this bill? And for me, it's that synergistic effect of they both feed into each other. So that's what I really enjoy about a business law perspective. And in terms of overlap with employment, there's a massive amount of overlap. I represent, from employment perspective, I represent companies and individuals. And just as a general point, for example, for most companies, their biggest overhead expense is their wage bill, is their salary. So on average, a company spends about 70% of their overheads on salaries, on things like holiday pay, sick pay, maternity pay. So again, when you're representing a company or an individual, particularly when you're in a negotiation perspective, and I find this a lot from when I'm representing individuals, again, being able to understand how companies work, how companies operate, how do they answer to shareholders, what do they do for quarterly meetings and reports, being able to understand all of those things means you can not only give your client practical and pragmatic advice, but it then also means that you can understand a bit more where to press with a company. So, for example, I've just recently done an advice on whether a claim against a company has merits. And the question is that my client, or one of the claimant in this case, has said that she was subjected to unwarranted and sexual comments from a senior member of staff. Now, as part of my advice, I said, okay, well, I want she was then dismissed, and the company said that she was dismissed for reason of redundancy. And I said, okay, I want your balance sheet. Show me that you are a company that was undergoing financial hardship. I'm not going to take your word for it. What I then found when they provided it was, first of all, they didn't provide a balance sheet. They provided a revenue sheet to show, well, this is all the money that we've made and we're losing money. And I said, well, that's not a balance sheet. You're not showing me what you're making. You're not showing me your profits. Why? And the second point is I then saw that one of the owners, the one that was accused of making these comments, actually had invested as a director within the company, which then was able for me to then make an argument saying, well, hang on, he then has a very personal interest of why he would want this person no longer at the company. It's being able to do that and being able to actually understand what you're looking at. Again, it means that you can ask the right questions. There is such a degree of overlap that realistically, actually, versatility can be your best weapon.
Thank you, Alex. Matthew, a question which I presume relates to the time when you were applying to Chambers for pupillage. The question is, why did you choose 42BR?
Well, it is what I said there. I really wanted a mixed practice. And so before pupillage, I'd done lots of different jobs. And so I was a paralegal, mainly in civil. I'd done lots of pro bono, for example, with human rights charities. And then I was a research assistant at the Law Commission, and that was on the self-driving vehicles project, which touched lots of different areas of law. And so when I sat down and thought, what chambers do I want to apply to and what sort of practice do I want? I wasn't really sure, other than knowing I had looked at all of these different areas and worked in these different areas. And I've just found working in law and thinking about legal issues and tackling those issues interesting. And so applying to 42BR and having the opportunity to give it a go and to have all those different areas, but not just the fact that we do all of those areas, we have experts in each and every one of those. And so being able to see members of chambers who are amazing family practitioners, amazing employment practitioners, amazing housing practitioners, it meant that that's the reason why I applied, so that I could figure out where and what my practice might look like without really knowing, but knowing that I'm going to be at a good set with good quality work and good supervisors who will provide the training I need to be a great barrister.
Thank you so much, Matthew. We are literally just at the time that we're due to end. I'm just going to finish off very quickly in the next minute or so, answering or trying to answer a couple of questions, or actually quite more than a couple, that have come in about individual circumstances where people are saying, well, if I've done this or if I've done that before, is that going to be a bar? Simple answer is no. I go back to what I said earlier about being your authentic self. So please don't worry about such things. We've also had questions about repeat applications and whether those are precluded. Again, no, we appreciate that people change over time. So you're not necessarily going to be the same person you were last year. So that's absolutely fine. There have been a number of questions about chambers more generally. So let me just say a couple of things. To the person who asked whether we had plans to open an annex in Kent, I'm afraid the answer is no. In terms of what we think sets us apart from other mixed practice chambers, in very simple terms, we, as you will see, and a lot of these questions, actually, you will find a lot of information that answers them on our website. We are significantly larger than many other mixed practice chambers. And what that means, and what you've heard, is that each particular practice group therefore has strength and depth within it. Some chambers where they have, where they are offering mixed practices may not necessarily have the numbers to have a significant depth in each particular group. And that's a great opportunity, as you've heard from Matthew, to learn from people in different areas. In terms of the supportive culture, I think everybody has really touched on that, so that I don't think there's much more that I need to say, other than at the end of the day, we are a group of individuals who work together, we come together, we support each other, and ultimately we are keen to ensure that everybody thrives. And as you've heard, particularly from Matthew, that doesn't just mean that the focus is on you and your practice, but it's also about supporting other people. And as a junior individual, you will get a huge amount of support, not just from your supervisors, but from other members of chambers. Any time of day or night, there will be somebody who you will know that you can call and ask for advice. And ultimately, what we are keen to do is to ensure that everybody is able to develop and maximise their potential. So on that note, I think I'm going to draw this event to a close. Thank you ever so much to all of you who joined. This is going to be uploaded as well, so if you want to listen to it again or you missed a bit, you're welcome to do so. Equally, if anybody did miss it and you can tell them about it, they're very welcome to watch the recording. If you are watching this recording and you have other questions, then please do drop us an email and we'll be very happy to answer them. And the same goes for anybody who did ask a question that we didn't get to answer, and I apologise, we had a huge number of questions. Please do let us know if there's anything more that you need from us. Otherwise, I wish you the very best of luck with your applications, and I look forward to meeting some of you at interview in due course. Thank you very much and enjoy the rest of your evening.